All right. Court of Appeal in the Fourth District of the State of Florida is now in session. Will carry Unit 1, Judge presiding. All persons having business before the court drawn here give attention and will be heard. May God save the United States of America, State of Florida, most honorable court. Please be seated.
Good morning and welcome to this session of the 6th District Court of Appeal here in Orange County today. I'm Carrie Ann Wozniak from Orange County. To my left, your right, is Petra Brownlee, also from Orange County. And to my right and your left is Keith White, also from Orange County. So we will go ahead and get started with our first case. One reminder is that we are being live streamed and recorded. And the first case is 24-0548. Florida Association of Realtors et al. Versus Orange County et al. Appellants, are we ready to proceed?
Yes, sir.
You may when you're ready. And how much rebuttal time would you like?
I'd like to reserve 5 minutes, please.
Okay, great. You may begin.
Thank you. Good morning, and may it please the court. Daniel Nordby, along with Eric Szabo and Alyssa Corey from Schutz and Bowen on behalf of the appellants. In 2022, the Florida Realtors and the Florida Apartment Association obtained an injunction preventing Orange County from enforcing an illegal rent control ordinance. Because of that litigation and the extraordinary effort of a 5th DCA panel on an expedited briefing schedule, that ordinance was never enforced. The trial court subsequently dismissed the case as moot without adjudicating appellants' entitlement to attorney's fees under Section 57.112 of the Florida statutes. This court should once again reverse the trial court. Unless the court would prefer otherwise, I'd like to begin with the legal framework providing for a mandatory award of attorney's fees in preemption challenges to local government ordinances, and then explain why appellant's challenge here under Section 125.0103 was an express preemption challenge of that nature, and then finally address why the collateral legal consequences of that pending fee claim operates as an exception to mootness under established Florida law. So first, Section 57.112 of the Florida statutes provides that a court shall assess and award reasonable attorney fees and costs and damages to the prevailing party in a civil action filed against a local government to challenge the adoption or enforcement of a local ordinance on the grounds that it is expressly preempted by the state constitution or by state law. The complaint here raises an express preemption challenge to Orange County's rent control ordinance.
It doesn't actually use the word preemption, correct? In the complaint, it uses prohibition, it uses some other words. Is there a difference between the language that was used and preemption?
I don't think there is, Judge Wozniak. The statute, neither 57.12 does not impose a pleading requirement that the complaint expressly allege express preemption. The nature of the claim here is an express preemption claim because what the complaint alleges, and I direct the court to the record at pages 8 through 29, especially paragraphs 7 to 12 and 31 to 36 of the complaint, which outline the preemptive framework and the county's noncompliance with it. Essentially, the ordinance was invalid because a state statute prohibited its adoption. That's the definition of preemption. And the 5th District, in its opinion in the injunction stage, recognized at pages 120 and 124 of the Southern Third that this was a preemption-based claim. The claim was that the ordinance was inconsistent with the statute and with the Florida Constitution. The complaint also alleges the fee claim under 57.112, which applies only to express preemption claim. So if the point of this requirement is a notice requirement, there can be no doubt that what the appellants here were asserting was an express preemption claim against the Orange County ordinance below.
Mr. Nordby, you just mentioned that is the paraphrase, that is the definition of preemption. What are you relying upon as your source for the definition of preemption?
Well, we rely on the case law that interprets in analogous circumstances what a preemptive statute is. We've cited the City of Aventura case from the Florida Supreme Court on a state statute that preempted local regulation of red light cameras. And the statute in that case had very similar language to the preemption statute here, to 125.0103. Also, the Freed versus State case from the Florida Supreme Court in 2023 addressed a statute providing for preemption of local ordinances addressing firearms. That statute, like the statute here, prohibited local governments from acting in a certain area. And the Supreme Court, in the case of the Freed case and the city of Aventura case, characterized those statutes as expressly preempting local government regulation. We've also cited the Florida Retail Federation case from the third DCA, which addressed a state statute prohibiting local ordinances on the use of styrofoam by businesses. The third DCA there also characterized those statutes as express preemption statutes, even though in that case and in the other cases, the words express preemption may not have been in all of the statutes that the court characterized in that way. So we'd point to those cases as providing analogous circumstances, and then to just the dictionary definition of what preemption means. And we'd submit that a statute is an express preemption statute if that statute by its terms prohibits a local government from acting in a certain area.
Do you think that's really the disconnect, in your view, from the trial court's perspective on this, is that he thought it had to say it's been expressly preempted by the state legislature? Like, because when you talk about the word search in your briefing, it struck me, and I think, you know, a loose term, if looked at loosely, these terms sort of might imply that, but when I look at the Masson case, it has that, or that local ordinances on a particular subject are precluded. And I wonder if there was just this disconnect where he's like looking for this terminology, this specific terminology, rather than the function of the statute.
I think that's exactly right. I think that was the one of the disconnects that the trial court had here. And I think it's one of the sources of our disagreement with our friends on the other side here is exactly what express preemption is. The county's position would essentially ask this court to read new words into 57.112. It would ask the court to read the fee statute as though it applied in complaints that expressly allege express preemption. But that's not what the statute says. And I'd also say that there's maybe a disconnect on different types of preemption here. The statute we're operating under here applies to express preemption. There is a concept of implied preemption where the state regulates pervasively in a field, but does not explicitly prohibit local government regulation in that same field. In that circumstances, there can be a judicial interpretation that the legislature implicitly meant to preempt local government from regulating, even if it didn't say so. That's not our statute. Our statute, 125.0103, starts off, no ordinance which would have the effect of imposing controls on rents shall be adopted or maintained in effect. That's express. That's not asking this court to look in the corners to find out whether local governments can act in this area or not. The other potential disconnect here is the distinction between express preemption and complete preemption, or what some of the federal cases call field preemption. So a complete preemption is a state statute that says local government cannot act at all in a certain area. Only the state government can enact laws or ordinances in this area. Or as I said, sometimes called a field preemption. That's not necessarily the same thing or inconsistent with express preemption. An express preemption statute can have exceptions. It need not be a complete preemption or a field preemption. And again, I'd point you to the Freed versus State case. It was an express preemption statute. It's what the Florida Supreme Court said, but it had exceptions. Local governments could regulate firearms in certain areas. The same thing with the styrofoam containers case from the third DCA. It was an express preemption statute with exceptions. It allowed some grandfathering and other things. So express preemption need not be a complete or field preemption or in order to in fact be express preemption and within the ambit of 57.112.
If we reversed and write an opinion, what should the remand instructions be? What's your position on that? Should it just be for the trial court to determine the prevailing party? Should it be for the trial court to determine if the statute was expressly preempted or the ordinance was expressly preempted? What would you like the instructions to be in the opinion?
So it's an excellent question. I think the latter question that you said is one that this court is well equipped to address. What does the statute say, and is it an express preemption statute? I think that's a legal question that this court is well equipped to address. I think the first question you asked is exactly what we would think the trial court needs to decide: who the prevailing party is, and if we are the prevailing party, as I think the facts will clearly establish, what the amount of fees to be awarded under this mandatory prevailing party statute are. That's what the 5th District did in the Mazer case that we cited. It was a public records case, also against Orange County, as it happens, in which the trial court dismissed a public records complaint as moot after the county provided the records late to the plaintiff in the case. The trial court dismissed it as moot, and the 5th District said that that was improper because there was a mandatory prevailing party fee claim that needed to be decided. So it was remanded for the trial court to make that determination.
But that statutory language was different, right? So in that case, they had to actually make a determination like on the merits. Like they had to make a determination as to whatever that statute says. And I'm sorry that I don't have it right in front of me. I can pull it real quick, but it seems to me that in your case, the statute just requires that allegation. And then once the allegation has been made, then the prevailing party gets fees. So, you know, there's just this fine point with regard to what the statute said in the other case. You have to make this determination almost like if it was exactly like our case, we would have to make the determination as to preemption and whether, you know, the other side has violated that. But so there's a distinction, right?
So there's some distinction in the statutory language. I think the concept or the framework is the same, though. And we also have the Soud case from the first DCA, which was an open meetings case providing for mandatory prevailing party fees. And in that case, too, the underlying dispute had become moot, but there was a prevailing party fee claim that the lower court still had to determine. I think the right framework for addressing the prevailing party issue would be what the Florida Supreme Court said in the Moritz decision in 1992. The unanimous Florida Supreme Court said that what remained to be done was to allow the trial court to determine from the record which party has in fact prevailed on the significant issues tried before the court. And that's at 604 Southern 2nd 809. So that I think is, going back to Judge Wozniak's question, is what the trial court would need to do. Examine the record and determine which of the parties have prevailed on the significant issues litigated before the court. We would submit.
What was the procedural posture in the Moritz case? Meaning, in your case, there was a temporary injunction. This was not after a final judgment on the merit. In Moritz, was it a similar procedural posture?
In Moritz, there were a few things going on in Moritz. There was a lawsuit seeking the return of funds that had been escrowed, and there were some issues that had gone in favor of one side and some issues that had gone in favor of the other side in the actual judgment the final judgment that went up on appeal. That did not arise in the context of a mootness issue as the case here did. But the significance of that case to our argument here is that it's useful for determining which side is the prevailing party in the case.
But if Moritz was after a final, the reason I'm asking is when you're saying that we should remand for a determination of the prevailing party, what, if anything, would the parties be entitled to present to the trial court in terms of additional evidence or arguments on the issues, given that the posture was a preliminary injunction, which doesn't defeat the party's ability, had there been a trial on the merits, to make additional arguments and perhaps new findings. Is that correct?
So you're certainly correct on the procedural posture here. It went up on a preliminary injunction. Although I'd note that both the original trial judge found a substantial likelihood of success on the merits for the plaintiffs. The 5th District affirmed that and then found in favor of the plaintiffs on the remaining points too. I believe the county has conceded that there is no more work to be done on the merits of the underlying claim. And frankly, our best day in court after a full trial would have given us nothing more than we received in this case from that preliminary injunction and then the underlying dispute going away. 125.0103, among the many restrictions on rent control in the pre-amendment statute, provided that these ordinances could only be in effect for 1 year. So by having this statute enjoined before it ever went into effect, I think it's quite clear that the plaintiffs here, the appellants here, prevailed on every issue that was decided in the case. So I again, going back to Judge Wozniak's question, I think that probably is properly a question for the trial court. It may be that on this record, there's simply no dispute and this court can make that determination itself and remand with just simply with directions to enter that order. But if anything remains to be done by the trial court, it would simply be that determination of who is the prevailing party on the issues that have been litigated in this case, on the significant issues that have been litigated in the case. We also cited in our papers a fourth DCA decision, a Chase Bank decision, to similar effect, that a final adjudication on the merits is not necessary for a party to be entitled to fees as a prevailing party. And again, the Mazer case and the Stout case go to the same effect there. Under Florida law, a final adjudication is not necessary in order to be a prevailing party. You simply look at who succeeded on the issues that actually were litigated. If there are no further questions, I'll reserve my time for rebuttal, but the legislature enacted section 57.112 to deter local governments from enacting unlawful ordinances and to ensure accountability when they violate preemption statutes. The appellant's fee entitlement claim is not moot and this court should reverse. Thank you.
Thank you. Apoli, when you're ready to proceed.
Thank you, Your Honor. May it please the court. My name is Greg Stewart of the law firm of Neighbors, Gibble and Nickerson, representing Orange County in this matter. Generally speaking, summarizing the law is that once a matter becomes moot, dismissal is the appropriate remedy. There are some limited exceptions, and what we've been talking about here today is the collateral legal consequences exception. It is a very narrow exception. And under that particular concept, attorney's fees can constitute a collateral legal consequence, but there must be a specific statutory basis. It must be a mandatory award, no discretion by the court. And there can be nothing else that needs to be done at the trial court other than dispose of that motion. We believe that in this particular case, that exception is just not applicable. Now, the primary point is that notwithstanding Mr. Nordby's argument, appellants are not entitled to attorney's fee award under 57.112, which is the statutory basis that they are seeking. And it's a couple of reasons. First of all, Judge Wozniak, you mentioned in terms of the complaint itself, but really they did not contest this on a matter of express preemption. And under that statute, it requires that it is challenged on the grounds that it is within expressly preempted areas.
What do you have to say about Mr. Nordby's citation to certain paragraphs in the complaint that he contends do state that? And I'm wondering too, is that because you think that they have to specifically state this has been expressly preempted by the legislature?
The ground, what the statute appears to be, the fee statute appears to be indicating is that where the legislature has set forth an express preemption and someone challenges it saying, you have now intruded into an area that is not open for local government legislation. That's what a preemption is. So if you look at the complaint as a whole, the two grounds they raise are that the factual findings of the Board of County Commissioners was inadequate under the guidelines of the particular statute as to what needed to be shown to, in fact, adopt a rent control ordinance. Second, the ballot language is insufficient. That's the two issues. The first one is dealing with whether he complied with the statute, not whether they were legislating at all. It's whether they complied with that statute. And I would indicate
But if they don't comply with the statute, and so it doesn't satisfy one of those exceptions, isn't everything else then precluded by the statute? So if they don't satisfy the exceptions, wouldn't everything else be precluded by statute and
Well,
further legislation?
No, going back a little bit in terms of let me talk a little bit about the history of that and to answer your question. But this statute was originally adopted in 1977, section 125.0103. The year prior to that, the legislature considered a rent control or statute, excuse me. And that particular statute specifically stated, just as the new amended one does, that local governments cannot legislate within this area. Again, preemption addresses a subject matter. And so that went to Governor Askew. Governor Askew vetoed that bill as an intrusion on the home rule powers of local governments. Very next year, the legislature again considered rent control and adopted what became 125.0103. That particular statute sets forth that in fact local governments have the ability to do rent control. That's really the only thing we're talking about under 125.0103 is rent control. And so they adopted that. And it's clear that the legislature did not intend to expressly preempt the area because they had included the language the year before that did that. And they did not include it in the 1977 enactment. So what we're dealing with here is the subject matter of rent control has been expressly preempted under the new language that the local governments cannot even legislate in that area. And that's what the difference is between the preemption.
Mr. Stewart, what would be your response? Mr. Norby's argument is, as I understand it, would be you're saying that what the statute means is there has to be express complete preemption. Alan's argument, if I'm understanding, would be no, as if it could be express complete, certainly would be included, but it could also be express but partial.
No, I don't believe, I believe that what we have here in the new legislation is a complete preemption of rent control. What we had before that, which was the county proceeded, was not a preemption at all, but it was basically a regulatory statute that basically set out, if in fact you want to do rent control, this is what you need to do. You need to do a study, you need to make certain findings. It has to support the grave public threat, and it has to be approved by the voters. It's a regulatory statute, not a preemption statute. That's the distinction
That's
that
being regulated.
the county, in terms of the county's authority to regulate rent control, that is what was addressed in the ordinance.
Right. So not regulating landlord and tenant relations, but regulating what the local government can do
For
in
rent,
in certain circumstances.
in certain circumstances, and that is rent control. That's what the issue really turned on in the county's ordinance, that it was a rent control, rent stabilization ordinance. And so it is not what Mr. Norby is attempting to do is to combine various limitations on county or city authority and merging them into one big bucket. For example, obviously counties and cities, if they are preempted from legislating in an area, then they cannot take any action within that area to enact a legislation or requirement. However, apart from that, counties have the authority to do any act under their home rule powers, except to the extent that it's inconsistent with general law or special act.
And that's where we are here, right? And then that gets us to general law, and then we just look to the plain language of the current statute.
Yes, but the difference is that if you have a preemption of a statute, let's say firearms, 790.33, that is preempted to the state. They are the only entity that has the authority to do it. If a county attempted to legislate there, it would be a violation of the preemption aspect, but it would also be a violation of the inconsistent with general law. It would violate both limitations on county authority. However, take another area, impact fees. There's a specific statute that deals with impact fees, 163.331.801. And that particular statute sets forth guidelines as to how the county or city may enact impact fees and what may be done. And if the county or city fails to meet those, that is then inconsistent with general law or special law, but it is not a violation of preemption. And that's the
Is there a
distinct.
case that's held that in that hypothetical, that maybe it's not a hypothetical? Is there a case that says that?
Is there a case that says that the standard is inconsistent with general law?
Well, in the concept of, regardless of the subject matter, if you have a statute that says local governments shall not accept if that sort of a statute, is there a case that says that sort of a statute, that sort of a framework that expressly prohibits government content? I mean, when you use the term regulation, to me, that seems like if the legislature comes in like they did in the election code, where they make all of these statutes about how elections are to be run, but they don't specifically have a prohibition on when local government could say fill in the gaps until the legislature did that
Right.
in a statute.
Right.
And so in that case, there's no mention of local governments in the election code. And so but there was the implied preemption. They occupied the field or not. That was the argument. So not that sort of a statute, but where the legislature specifically says local governments can't do anything at all under any circumstances, or they can, but here are the requirements, and whatever the legislature determines those requirements. Is there a case that says that's not express preemption?
Well, I'm not sure I do know of a case that's specifically that factual circumstances. There are cases that,
Well, let me ask you this follow-up then, that I asked Mr. Norby. What is the source of your definition of preemption?
yes, I agree with Mr. Norby that the definition of preemption, and particularly express preemption, is developed through case law. And the Brevard County case, the Clearwater case, Clearwater Fireworks, and the Santa Rosa case, they're cited in our brief, pretty clearly set out the analysis that exists as to what type of preemptions are out there and available. It goes without saying that express preemption is, they call it express preemption because there's an actual statement in the statute.
And what does that statement in your mind have to say?
It doesn't have to use magic words, but it
Okay.
does have to indicate clearly that the authority of a local government has been taken away to legislate in this area.
Okay, so can I just read you? So if ours says in sub 2 of 125.0103, no law, ordinance, rule, or other measure which would have the effect of imposing controls on rents shall be adopted or maintained in effect, except, and then the 5th DCA says you don't qualify for those exceptions. They decided that.
Right.
What is it about that language? What am I missing?
Because the remainder of that section of I believe it's subsection 5, but I may be mistaken on the subsection number, but that's the one that sets out about the findings. So there was language that the county was operating. It was not, there was a specific procedure that was within 125.0103.
Right.
And that is, so it is the general rule, I agree, is the statute is saying you cannot legislate in this area, except this is how you need to do it. Similar to impact fees, you cannot do an impact fee unless you meet these.
But isn't that the same thing? So sub 5, and I appreciate you clarifying that for me. No municipality, county, or other entity of local government shall adopt or maintain in effect any law. Why? So if there's no magic law, or if there's, excuse me, no magic words, what about that is permissive? Take away the exceptions. Because we don't, because the county doesn't qualify for the exceptions according to the 5th district,
Well,
correct?
the statute under which we proceeded prior to the amendment in 2023 gave the counties the ability to do rent control if they in fact followed a procedure. I agree that if they didn't follow the procedure, it would be invalid under a situation where you are inconsistent with general law, not preemption. And so they're saying, this is the way you need to do it. And so that, I believe, is the distinction here. We're not dealing with an express preemption in the 125-0103. That is, I agree that language is there, but you have to look at the entire statute to recognize that what it is telling local governments is that if you are going to legislate in this area, or you want to legislate in the area of rent control, this is what you can do, and it would be acceptable.
So am I correct then that is your primary disagreement with Mr. Nordby then that with regard to the exceptions, once it lists a particular procedure or exceptions, then it can no longer be express preemption?
Well, my view on express preemption is that the point of that is to go ahead and basically take an entire area. And you do it either by saying in the statute that you shall not do rent control, or you do it by regulation of the implied preemption, which is you basically regulate the entire area and there's no room to legislate. But we're not dealing with implied preemption, but that is not present in 125-0103. What we're really talking about in terms of, if you want to look at the limitation of county authority, is that there was a process that was set forth in the statute. The county did not meet that statute. Therefore, it was inconsistent with general law. That's different from preemption. That is a separate limitation of county powers or city powers. They have the same limitation.
Mr. Stewart, though, in this particular case, I think I understand the distinction you're trying to make, but reading the complaint, are you saying that complaint doesn't allege that the ordinance was defective on its face for insufficient findings? I mean, isn't that exactly what the 50 CA determined?
Well, I think ultimately that's correct, but the issue here is, how does that affect a express preemption? So, because we're dealing with the fee issue, which only will come into play if in fact that the legislation is found to have been in an expressly preempted area. We submit it is not a preempted area. At that time, it is now under the new amendment that was adopted in 2023. And in fact, one way to look at this, the Supreme Court has considered the issue of the attorney's fees in this case already. And as you may recall, that following the reversal of the temporary injunction order of the trial court by the 5th District, the county appealed to the Florida Supreme Court. And while they were considering whether to take jurisdiction, the legislature acted to amend 125-0103 to then expressly preempt the area. There was a pending motion for the appellant's attorney's fees, and the Supreme Court denied the attorney's fees. There's really only two reasons they could have denied it. One, it's not mandatory and they had the discretion not to award it. Or the second is that it was not a preempted area and they are not entitled to fees.
So it's law of the case.
I think it is. Because there isn't, under either of those arguments or rationales, is fatal to their argument here today.
But how do we know what the basis of the justice's decision was? They didn't articulate any reason at all.
They did not. But looking at it in terms of the issues that were before, it was solely based upon attorney's fees and whether they met 57-112, which is the statutory one. That is, I would go on a limb to say there's nothing else but one or the other had to be the basis.
Well, but what about the language that talks about when the definition of, give me one moment, find it. Subsection 1 of 57.112, because I did read that argument. I thought it was intriguing. I looked at the Florida Supreme Court's order, didn't see any reasoning, but subsection 1 says attorney's fees and costs means reasonable and necessary attorney's fees and costs incurred for all preparations, motions, hearings, trials, and appeals. I mean, that was a discretionary review proceeding. Maybe that does, maybe they determined that doesn't fall within the definition of appeals.
I don't think it's a discretionary, I mean, I don't think they have that luxury if it's mandatory.
I mean, appeals,
It seemed to have covered.
it's a strictly statute, be strictly construed, right?
Well, and so that's the issue is that if in fact, I mean, the whole purpose of this collateral legal consequence is that there's a matter that really, there's nothing else to accomplish other than just sign the order with award the attorney's fees. That's the intent, because you can't have any other issues to resolve either. Which, and so the Supreme Court has the exact issue that you have. They have attorney's fees. We have,
Well, and I asked Mr. Norby, what's your response? What other issues are to be resolved? And on remand, what does the trial court have to do in your view?
well, I believe that the law in Florida, and I think we cited it in our brief, is that a determination on a temporary injunction is not a final determination on a case. So I think there needs to be a final determination. It may not change, to be honest and frank, but I think that needs to be done. I think the issue.
Under Florida law, you think there always has to be a final determination, like a final judgment on a case? I mean, what about a voluntary dismissal? Where someone could be entitled to fees?
Well, and I'm not saying in all circumstances, but I'm saying that the posture of this particular case, where we're coming back remanded after temporary injunction was reversed, or denial of a temporary injunction was reversed, there is no final determination at this time. There's no dismissal that has been entered that the court could say, well, they dismissed the case. They're the prevailing party. Granted, I don't want to contend that the facts are such that it's going to suddenly change, but that is a legal step. But I think the bigger issue is that I think this entire issue concerning entitlement to fees and whether this is an express preemption is another matter that needs to be resolved at the trial court. If in fact, unless this court directs them that is how it's going to be and that it be already determined.
Well, what would it be inappropriate? Are you saying that in the posture before us, there's some additional factual findings that the trial court up to this point has not made, and so therefore it'd be premature for us to make a legal ruling?
The problem with the remand from the county's perspective is we now have a statute that does in fact preempt it, and not only preempts the adoption of a new one, but it preempts a situation where you enforce an existing one. So the reality is the new law has undercut the authority of the county, which is a change of circumstances. It wasn't present when it was originally before the trial court. But I think that there probably would need to be some type of determination as to who ultimately prevailed and whether it may not need to be a final judgment, but I think that's going to happen. But I think the entitlement is a pending issue, and that would also bar this from being granted as a collateral legal consequence. And we would ask that you affirm the trial court, remand it to the trial court for dismissal as it's moved.
Thank you.
Morning again. Just a few brief points on rebuttal, because I think that colloquy did help to highlight the disconnect between the parties' positions. First, on the Florida Supreme Court's order denying fees. It's an unelaborated order. It has absolutely no reasoning. A friend on the other side suggested two possible reasons why they would have denied fees. Judge White's explanation, I think, is a more compelling one. The statute provides for an award of prevailing party fees as to appeals, among other things. Is a petition to invoke discretionary jurisdiction an appeal? There's a reasonable argument that it's not.
Just so the record is clear, I do not claim to be able to discern the minds of the Florida Supreme Court justices.
And Judge, my broader point is we don't know why it was denied. It's an unelaborated order that provides no reasoning, so it's certainly not law of the case or binding in any way. That explanation would, however, explain why the Florida Supreme Court denied fees for that limited part of the proceedings, while the 5th District awarded fees for the actual appeal of the non-final injunction order. So I would submit we don't need to give much attention to that order because it doesn't provide any reasoning or any other applicability to what we have here before us. The last point that was made, or one of the last points, was about whether a final decision is needed. I believe the case that was being referred to there is the Bernstein case in the third district. That was an entirely different procedural posture. A party had obtained an interlocutory injunction order, and while that injunction order was proceeding and the case was still going forward in the trial court, they tried to obtain a prevailing party fees award for winning the injunction early in the case before the rest of the case had been decided. That's a very, and the third district said that's improper. You wait till the end of that because there has been no final order ending the litigation by judgment or other dispositive order. That's a very different situation from where we are now. We think the trial court would be well positioned to enter the dispositive order resolving the case and the order on the fee entitlement here. And then finally, unless the court has questions, I wanted to go back once again to the differences between different types of preemption that have been discussed and why the fee statute here refers to an express preemption. It does not refer only to statutes that both expressly and completely preempt local government regulation in a certain area of law. The former version of section 125.103 expressly but did not completely preempt the topic of rent control. The new version of section 125.0103 both expressly and completely preempts the regulation of rent control by local governments. In both cases, however, the statute expressly preempts rent control. Its words say no ordinance shall be adopted by a local government. That is about as clear a direction to local government on the scope of their authorities as you can get. Absent that statute, Orange County would have home rule authority, subject to constitutional constraints, to adopt ordinances on the topic of rent control. With this statute, they don't. That's preemption, that's express preemption, and that's why a collateral legal consequence should have been recognized as an exception to this.
Mr. Mundy, do we really need to decide that? And I guess this goes back to Judge Wozniak's earlier question about the remedy. Even if we were to agree with you that it is expressly preempted, isn't the statute, isn't 57.112 just asking us to look at the challenge that you brought and whether you were in fact the prevailing party or your client was, right? So do we need to really get into whether it's expressly permitted? I think a large majority of the argument today has covered that, but I'm wondering, it seems to me to be somewhat different from, let's see, I had finally pulled it, the Mazer case where they were looking at section 119.12. And that provision stated, if the court determines that an agency unlawfully refused to permit a public record to be inspected or copies, the court shall assess an award against the agency responsible. And it seems to me that our language is quite different and maybe we're just directed to the complaint, but what's your position on that?
I think that's right. The language is certainly different and the findings may be different here. I do think it's important for the court to determine that this complaint alleges and proved an express preemption claim rather than an implied preemption claim. I would agree that if what we had asserted here was merely implied preemption, there wasn't a statute specifically prohibiting local government from doing something, and we were just implying that it shouldn't, then the statute would not apply. But our statute does apply. That's why it's an express preemption claim. And that's why very little would need to be done by the trial court either. I think really the determination of which party prevailed on the significant legal issues tried before would be essentially the only thing left to be done on demand. See, my time has expired. There are not further questions. We'd ask this court to reverse. Thank you.
Thank you very much. Well argued on both sides. Do you need a break? You need a break?
I'm okay.
Okay. Okay, we're going to go ahead and proceed to the next case. We'll give counsel a minute to get switched out here. Okay, the next case on our docket is 23-4158 Dawson Parton Carbell Calderon versus State of Florida. Appellant's counsel, are you ready to proceed?
Yes, Your Honor.
Okay, and how much time would you like for rebuttal?
I would ask for 5 minutes rebuttal and reserve any remaining time, Your Honor.
Okay, thank you. And you may begin.
Good morning, Your Honor. My name is Brendan Mula. I represent Dawson Parton Calderon with Mr. Ali and Zach Starmbos seated at council table. Your Honor, this incident initially occurred on June 14th, 2021, which there was a battery. My client, Mr. Calderon, was the defendant in that matter. Following that, there was a subsequent battery that occurred in 2022 in which the alleged victim's son was involved in the battery. In that matter, there was a vehicular accident. A pickup truck crashed into Mr. Calderon's four-wheeler, resulting in injuries. That case was subsequently no-infoed by the state. Following this, in December of 2022, Mr. Calderon pled to the lesser included offense of battery, not battery on a person of 65 years or older, but a simple battery or unwanted touching. Following that, there was a restitution hearing held to determine how much restitution Mr. Calderon would be liable. In that hearing, that was conducted in 3 parts. The initial hearing was done in July, September, and the final ruling came out in October of 2023. During that hearing, Mr. Calderon, or Mr. O'Berry, the alleged victim, had testified that he sustained injuries that made him unable to work, and also submitted medical records and bills to the court over defense's objection for hearsay. It is important to note too before this court that the medical bills provided as well as the medical treatment rendered to Mr. O'Berry occurred about 18 months after the initial battery, some of which within 6 months of the restitution hearing. And this timeline is very important for one reason and one reason only. That is the issue of causation. Now, in determining whether or not to grant an order of restitution, there are 2 things that need to be determined: whether or not it is substantially related and whether or not there is causation to the underlying criminal offense. I would proffer to this court that while it is possible that someone who has injuries from a battery can be in fact injured, there is a lack of a causal relationship. The case law is very clear in that it likens restitution orders and causation to tort law, meaning there needs to be proximate cause and an actual cause or but-for causation. I would proffer to this court that there is no proximate cause, nor is there any evidence of but-for causation as provided on the record. In the instant case, we have a battery that occurred in 2021 and a separate battery that occurred in 2022. That one resulted in injuries.
I thought I remember reading that the injuries were to the other party in the second incident.
It's my understanding that Mr. O'Berry was injured. He was riding on a four-wheeler that was crashed into by his son riding a pickup truck, and he had injuries that he sustained to his face, and he crashed his face down in the windshield area. Now, with regard to but-for causation, the record is silent as to any actual but-for causation, whether or not the injuries were caused by the first battery.
What would be required in your position? What is your position as to what's required to meet proximate cause and but for? Is it not enough for the victim to get up and say, I think he said at one point, I remember reading, well, I'm wearing this hearing aid now and I could hear fine before the incident. Like, that's not enough?
I would argue it's not, Your Honor, especially given the circumstances of the case. Mr. Calderon, or Mr. O'Berry, excuse me, at the time of the incident was 75 years of age. He was getting pretty up there, and a lot of these injuries could have been, in fact, caused by the natural aging process or by what happened during the second incident.
Is there something under the law that tells us we would need something more than his testimony? I mean, say, say he says, for example, I've never had arm pain before the accident. The accident happened, I immediately had arm pain, right? And I know that that's just hypothetically, right? But if he says that, couldn't the finder of fact take that as evidence related to causation? And if not, if that's insufficient, Is there something under Florida law that tells us that's insufficient?
Under Edwards v. State and Quilly v. State, there needs to be substantial and competent evidence.
Mhm.
This is just testimony from the alleged victim in of itself. While his credibility was not assessed at the lower court's hearing, he is the opposite party, and I will get into that more when I get to the next point regarding the hearsay arguments.
What do you mean his credibility wasn't assessed?
There was never a finding of credibility on the court's ruling on October 25th of 2023.
I mean, the trial judge didn't state a ruling?
Correct.
Is that required that
No,
that
Your
the
Honor.
trial judge make a statement on whether a particular witness was credible or not?
No, Your Honor.
Can you talk, counsel, about the role of hearsay in restitution hearings? There's certainly a statute on point, and it seems to allow it as long as there is a sufficient indicia of reliability. Can you talk about that? I see some case law where the dates aren't clear to me of when the restitution hearing was held and whether that statute was still in effect. But there does seem to be case law that's sort of all over the map. And I think it's because of the statute and the timing of that.
Absolutely, Your Honor. To your point regarding hearsay, hearsay is admissible provided it shows a minimal indicia of reliability.
And what is that to you, that latter point?
I would articulate it as being more than just a mere signature. There must be some indicia that it is in fact reliability. And I think the credibility of witnesses and the false facts taken as a whole need to be considered. I would point the court's attention to three cases specifically on that point. That is Love v. State, which is at 338 Southern 3rd 257. That's a 4th DCA case from 2022. Johnson v. State, which is at 856 Southern 2nd 1085, and IM v. State, which is at 958 Southern 2nd 1014.
I'm sorry, was that initials IM?
IM, yes, I.M v. State. And that's M as in Mike. Now, these three cases stand for the premise that while hearsay is admissible, if there is a proper objection raised as to hearsay, it cannot be used to determine the amount of restitution in a vacuum.
Okay, so that's what I'm wondering is, do you think that these cases came out? Do you think that the statute that governs this now was in place at the time of these cases? Because that's different than stating what you just stated about, well, you can have hearsay unless there's some valid objection. That seems inconsistent with hearsay is allowed as long as it meets some sufficient indicia of reliability.
Well, I agree. There is a disconnect between the statute and the case law. I think the case law is in fact controlling here because Love v. State is a.
Why is the case law controlling?
Love v. State came out in 2022, directly prior to this incident. In that case is
So is
citing.
it construing the pre-amendment or post-amendment statute?
I believe it's construing the statute as existed at that time, Your Honor. And in that
This
matter,
didn't
No.
provide for hearsay, is that,
I'm sorry, Your Honor.
that statute that it was construing didn't provide for hearsay being admissible?
I do not believe so, Your Honor. I have to look at to double check to be sure. I don't want to mislead the court, but my understanding is this is the law as it was at the time.
Yeah, I guess my question is, so if it's a 22 case, if the incident happened before that, it could have been before 21 when the statute changed. We don't
Correct,
really
Your.
know which form of the statute that they're using.
Correct, Your Honor. And Johnson v. State was a 2003 case, and so was IM v. State was also a 2007 case. That was the first DCA. And again, McCowan v. State as well. That's 46 Southern 3rd 174 4th DCA 2010.
So those all predate the statute that applies in this case.
I would argue that the statute that applies in this case, the incident occurred in 2021. I would argue that they do apply in this matter. The hearsay should not be considered in and of itself without anything else. And there were numerous objections to hearsay that were in fact laid on the record in this case by the state.
Was this specific argument made though, that this version of the statute does not apply, that allows hearsay if there's a minimal indicia of reliability?
That argument was not raised at the, well, these three cases actually were in fact laid on the record in the trial court level. Love and IM is actually cited in this court's decision in October. It does cite to that case the language in IM v. State says in this case, Greg King did not have personal knowledge of the value of the ruined items, but upon the opinions of vendors who did not testify on remand, written estimates may suffice so long as they satisfy the requirements of a business record. And I think that gets into the state's argument a little bit. In the state's brief, they state that there's always a chance they could have it remanded and come back as a business record. That wasn't done in this case. The matter was continued several times over a defense's objection prior to for medical records provided by the state. And never at any time was there a business record certification that was provided by the state in compliance with 9803 subsection 6.
I guess that's my struggle is what you're saying. If that's true, then okay, grant you, we should remand. But if the statute doesn't mention anything about that, right? The statute permits hearsay as long as there's a sufficient indicia of reliability. So then you wouldn't have to meet a business records exception. And that's what I'm wondering is the statute that appears to govern your case doesn't require an exception to the hearsay rule.
Correct, Your Honor. But the case law that comes after does state that,
It comes out after that statute.
or it comes out, the case law I'm relying on, Love v. State was a 2022 case, Your Honor. The incident and bar occurred in 2021. I do not know the exact date the statute was amended, but it's my understanding that there needs to be more than just hearsay in order to substantiate an award of restitution. I would argue in this case that the facts indicate that where there's nothing else that was shown but hearsay from the defendant. In this case, the alleged victim said he made between $75,000 and $100,000 a year and made about $3,000 to or $2,500 to $3,000 a month with this business that he claims was affected from this incident. I would proffer that because there were no business records, there were no tax returns, anything that would have been used to substantiate that, he's operating off of hearsay. All his knowledge would come from tax returns, business records, any documents that he would have to. He doesn't sit out and count how much money he makes. He gets that from a third party or another source. So that information would be predicated on hearsay.
So every time someone testifies to how much money they make, they have to bring in a document to prove it.
I mean, I would say their knowledge is in fact predicated on hearsay. They're not the person who makes those records, not the accountants who total that amount of money. They would have to have some sort of document. Otherwise, they're basing their knowledge on an out-of-court statement that's being proffered for the truth of the matter asserted, i.e. how much money I make.
What if it comes from a contract? Like an employment contract, which has an independent legal significance. Case law is legion that says that's not hearsay.
Then that would have to be set on a case-by-case basis. If there is in fact a contract, we have no evidence of any kind of business contract that was provided in this case. So while statements of a contract are technically not hearsay, we have no indication that there was a business contract or anything like that that would have given Mr. Calderon the amounts of money that he made per month or per year, depending however you want to look at it.
He could have personal knowledge of that. It's his business. He
There,
takes the money from his customers and puts it in his bank. That's hearsay.
I don't believe that testimony came out on the record, Your Honor, in this case. If that's the case, then no, it wouldn't be hearsay. But if he is getting that from a tax return or another document, then in fact, it would be hearsay.
Was there cross-examination of the witness that elicited that in fact the source of his testimony was hearsay?
I believe he was just cross-examined on how much he made, Your Honor. I would have to look at the record again to verify. I would turn now to
Was the exact argument with regard to the income, will you remind me at the trial level, was it that would be hearsay? Is that the sole argument that was put before the trial judge
yes, Your Honor.
with regard to the income?
The primary argument was based on hearsay without anything to substantiate it, Your Honor. And again, there's all testimony from Mr. O'Berry. Turning to my third argument, and Your Honors, is the issue.
I'm sorry, I want to ask you.
Of course.
Are you aware of any case, other than some of the cases that you cited, any other case in a criminal case or a civil case, that documentary evidence is required to prove an element of the crime or the civil act? Testimony is insufficient as a matter of law.
With regard to restitution, Your Honor, no, I do not have any case law that.
Not limited to restitution,
I'm sorry, could you please clarify your question?
meaning like a crime. So they have elements. Civil cause of actions, they have elements. Are you aware of a case that holds, or a statute that holds, that testimony is insufficient by itself to establish an element.
I would argue or liken this to a felony DUI with two priors, Your Honor, because the case law is very clear that, or the statute actually says you need to have either a driving record or a certified JNS report to bring in those elements. Testimony in of itself is not sufficient. So I would like.
Because the statute said it.
Correct. The statute does mandate that there be a certified JNS report or a prior driving record in order to illustrate the prior DUI for the individual to be convicted of a felony.
Aside from where the statute expressly establishes that evidence, that documentary evidence is required, are you aware of a case where the statute doesn't specifically say that, but requires nevertheless documentary evidence to prove that particular element?
Not to my knowledge, Your Honor. Turning towards my final prong here.
You are into your rebuttal time. You can use it how you
Oh,
want.
I apologize. In that case, if I may briefly conclude, for the foregoing reasons, I would argue that this court should reverse the lower court's finding, as there is a lack of proximate cause, but for causation, and the hearsay was the only basis for determining the amount of restitution. Thank you.
Thank you. Counsel, you may proceed when you're ready.
Thank you, Your Honor. May it please the court. My name is Richard Palace. I represent the state of Florida. I want to answer Your Honor's question right off the bat here about any case law requiring solely documentary evidence here. There's none that the undersigned is located. All I have seen in all cases, and being specific here to restitution issues, is competent, substantial evidence. Here, we're looking at relevant material and also admissible evidence is what we're doing, something that will be adequate to reasonable minds to prove a fact. That is our definition of at least competent, substantial evidence as defined by the case law.
Testimony to me seems equal to documentary. I mean, it's all evidence, as long as it's
Yes, you're right.
admissible, there could be hearsay issues, things like that, but.
And of course, even beyond testimony, direct evidence from testimony or circumstantial evidence in testimony. As referenced in certain DUI cases, certain things need to be certified. When we go into cases such as possession of a firearm by a convicted felon or the like, it's required that the actual JNSs or a stipulation, I'm sorry, do not mean to speak in abbreviated terms, but the judgment and sentence are either certified, entered in, found in a bifurcated hearing, or of which there's actually a stipulation to them for purposes of keeping out prejudicial evidence. But here, testimony certainly would work, especially in a case where we are dealing with a majority of this amount being lost income by someone who owns and does the primary work of his business. The victim here was working in a business of building, mending fences. In fact, at the day of the offense, when he was attacked by the appellant, the victim.
You agree the state bears the burden, correct?
You are correct, Your Honor. The state bears the burden by a preponderance of the evidence. We need to prove
Preponderance of the evidence?
preponderance of the evidence. That is what is listed in the text of 775-089. We must establish it by preponderance of the evidence, and we can introduce hearsay if we have a minimum indicia of reliability.
What's your response to this case law? Do you think that possibly the statute that the incident at the time, like that statute hadn't come out at the time of at the time of the restitution hearing? Sorry, my words are getting jumbled, but I'm wondering if there is a time problem here that's not reflected in the case law, because otherwise the case law does seem to say what he's saying, and I just can't reconcile this with the language of the statute, which leads me to believe it predates the amendment.
Certainly, Your Honor, and to answer whichever half first of that. First, unfortunately, the undersigned did not, of course, brief these arguments, and these weren't brought up below. I know the statute was, the last amendment was 2021. And of course, there's been countless amendments beforehand in 2015 in going forth. I'm not entirely certain under the statutory history of this statute when the hearsay and indicia of reliability was entered in here. It is possible it goes between them. And of course, if this court found this to be a very dispositive issue here, the state would be willing to engage in supplemental briefing.
Well, I guess I was just trying to clarify what the applicable law is. So with regard to the hearsay, I mean, do you think that there has to be some exception in order for the hearsay to come in once the other side objects? Or do you think it's just fair game, almost like a VOP hearing, except then, you can't solely rely on that hearsay?
Well, yes, I don't believe that this is a situation where hearsay cannot solely be brought in terms of the VOP cases. I think all we need is the minimum indicia of reliability. And I believe that's going to be a case-by-case basis. Again, going into competent substantial evidence being the only form of the standard of review I know of here. And the subsequent form of review is, of course, an abuse of discretion. If reasonable persons could disagree as the trial court's findings here, of course, we are going to find that is not an abuse of discretion in this case. And I think in this case, looking at it case by case, someone actually testifying in detail to what his work entailed, what he was doing and how he was feeling before he was attacked. And then going into painstaking detail in his testimony that, excuse me, Your Honor, that he was unable to engage in this work any longer from the time of this offense, not just to the time of this subsequent battery that allegedly occurred in March, coming before the plea was entered, but in all the time leading up to that, as well as to the time of the hearing where the trial court cut off the future earnings in its ruling.
So testimony his testimony was enough without having to provide documents, and feel free to get your water if you need to.
Oh, I appreciate it, Your Honor. Just needed to clear the throat.
Okay, no
Thank you
worries.
very kindly.
So I think I lost my train of thought, but okay. If his testimony is enough, I was a little troubled by his actual testimony being maybe not the clearest as far as his losses with income. I think he said, I think I've made between 75,000 and 100,000 in a year. There was kind of a range. It seemed a bit vague. Is that enough? Can you assuage my concerns about that maybe the testimony was a little bit too vague for a concrete restitution award on that?
Your Honor, I would assuage that by the worst case, I would argue, in terms of testimony being too vague, I think is the Johnson case, if I'm getting these together here. And the Johnson case being where the victim did not testify. We just had the victim's daughter, the victim's attorney, as well as a form that was allegedly prepared by the victim's accountant, but was not, of course. There was no testimony of how that accountant came to those numbers. And in that, they talked about the net worth being somewhere between, I want to say $2 million and in the 750,000. And then the net worth upon meeting the defendant, because I believe that was abuse of an elderly person case. In that case, it had been lowered down to 100,000. That was testified by not the victim, but the victim's daughter, someone who had possibly knowledge into her mother's affairs. But because of that, they found that was speculative hearsay. It was not going to come in. We don't have that here. No one of the victim's family was testifying as to what happened in his business. We don't have someone looking over his books and saying, I think it's this. We have the actual person who runs the business here.
But he couldn't tell us the amount, right? He's like vaguely stating a range.
That is correct that he mentioned between 75,000 and 100,000 at one point. I want to say 4,000 might have found its way into the record.
Per month. I saw
Per month.
that
About
something.
per month at another point. And of course, the trial court did not award that amount there. If
What to make of that? I mean, are those hard numbers? Does the case law require that?
I would here, of course, we need to look into, of course, going into 75,000 a year, that wasn't even necessarily awarded in this case. It kind of seems like the trial court, as they discussed that this went between 20, I recall there was at one point, they said between 2,500 and 3,000 or 2,500 and 4,000. The trial court wanted to go with a different number here. I think that.
Is that permissible?
Well, in an abuse of discretion standard, Your Honor, in a case-by-case basis, at least with the way we had this case here, I would argue that it is reasonable.
Because she went down, not up.
I would argue it would really need to depend, if we had a lot more detailed statements could have gone up. I think it's important here that, there's a lot of talk of doctor's appointments and the like that occurred after the plea colloquy had occurred, in this case before the restitution, but nothing awarded, I believe, was from the dentist office at that time. Nothing of when the soldier surgery had recently been prepared, because I know the victim was in a sling at the time that he was testifying. We, of course, didn't have anything itemized from those to a certain degree. I know some was listed in the memorandum filed by the defense opposing the restitution awards. But I would argue here that the trial court had a lot in front of it as to how it could award this. And I would say that certainly, while there could always be more detail, if we're looking at this through the mind of a reasonable jurist and whether reasonable jurists would disagree, here they're saying 75,000 a year. That wasn't even necessarily awarded. We were only awarded amounts for 2 years. The judge went by a 3,000 per month number, and they counted from the time in June of 2021 when this attack happened until when the restitution hearings began in July of 2023, and the judge cut it off at that point. I would argue at a very maximum this court would do, if this court is unpersuaded by that evidence, is just merely remand, possibly for the limited evidentiary purpose of backing up those numbers perhaps more if needed. But it's noted here that going again into whether or not this was from a 1040 or however his business filed its tax returns, even if we argue that is hearsay, we have a minimum indicia of reliability here, because who would know better about his business than the victim who owns this business, who's been working this business all his time, and again, was working this business at the time that he was attacked by appellant. And I want to just briefly go, and we were talking about those cases, and I want to get to the other half of your question, Judge Brownlee, regarding whether or not we are in trouble here with the IM case, the Johnson case, and the Love cases. And I don't think that those cases are, of course, this court has made it clear it is able to, we are only controlled, of course, by the Florida Supreme Court, United States Supreme Court here. We're not controlled by the courts in IM, Johnson, or Love. And I would argue that if this court finds that the statutory scheme is misread in those cases, or the statutory history of the restitution statute was wrongfully looked into, I would argue that this court could rule against those. But even if those cases this court thinks got it right for those particular facts, in the gist of treating like cases alike and different cases differently, I think those cases are all different. IM was about the market value, and the director of the company in that one was testifying to what he was told. He had no personal knowledge of whatever the market value was. And that's very typical in theft cases or any cases that get into property and the like. Fair market value is a big reversal point when we're getting into that. We are not dealing with theft here. We're dealing with battery. We're dealing with battery on a victim who was injured enough that he could not work anymore in his business. Going into Johnson, I mentioned earlier that we did not have the victim's testimony.
So, Mr. Palace, in essence, your argument is, in looking at the case law, that they stand on their own facts. We need to look at the facts here, which your position is here. It's sufficient because the victim himself testified about his business.
Yes, Your Honor. The victim testified about his business. The victim here already described that he was unable to work when he made his impact statement at the plea colloquy, when restitution was first getting ordered and the hearing was getting sent off. He then went into what his work entailed. I know there was talk, of course, about at the end of or the tail end of Topside here, we were getting into the experts and the like and talking about possible pre-existing conditions and the like. The defendant or the victim here was testifying that he was able to do his work no problem. The most injuries he would normally get is while moving posts or mending these fences. You might get a cut or something while carrying a post on your shoulder, a bruise or some form of abrasion. Not something where his shoulder is now injured, where he's having trouble hearing and where the man had to take an ambulance ride because of the way that he was attacked. In this particular case, I would argue we have certainly more than sufficient evidence based on the victim's own knowledge of this and how he did this work, how he was capable of doing this work. And he stated, I've had no contracts come in since then. He stated that he's resorted to having to sell property, whether equipment that he had or potentially land. I would argue here that this is what keeps this case out of all of those other cases, including the Love case. While that one might have involved the victim, they were talking primarily about what they paid in attorney's fees regarding, I want to say that was the one about a discovery request case. But with that one, they paid an attorney of it $300 an hour, but there was no testimony in what the attorney went through. It was almost as if we were getting into attorney's fees cases where we need to explain the work that goes into why we're earning the fees that we are and why we say we're paying them $300 an hour and we're asking for $300,000 in attorney's fees. So I would argue all three of those cases are distinguishable, Your Honors. And just to touch a little bit more on our expert testimony here, it was excluded, of course, is not relevant. I think it is very clear. If my physician heard me talk about my pain and didn't do any testing and merely told me, oh, it's just because you're getting older, I'm going to find a new doctor. This would be irrelevant for purposes of this hearing to have allowed Dr. Wiley to testify to this. And further, I would argue that even though the trial court only made its findings on relevance, I would argue sometimes relevance is part and parcel with reliability findings under Daubert. And we certainly don't have principles and methodology testified here or proffered here. And even if those were subject to the proffer, I would argue we have no way that they are reliably applied to the facts of this case without this doctor actually examining the victim here. If this court has no other questions, I will rely on my brief and just in sum, I would argue that we have competent substantial evidence for the amount that was awarded here. And I would argue it was not an abuse of discretion in allowing this particular amount that the court imposed. If this court has no other.
I have
Yes.
a question because I'm just still on this hearsay issue. On
Yes.
page 23 of your answer brief, you state, and I understand this is just sort of a fallback thing. This is not your primary position on this, but the last paragraph reads, the state lastly notes that even if this court found harmful error due to hearsay, the state would be permitted to submit this evidence as business records at a hearing with the proper foundation. So
Yes, Your Honor.
you're saying in an abundance of caution, if we find that is required under the law, then the state should be permitted an opportunity to do that and sort of satisfy some exception to the hearsay rule.
Yes, Your Honor. In the event this court finds that evidence, was either speculative or was insufficient to meet what our burden is, the state's asking for this court to remand for the limited function of further evidentiary hearing in getting this evidence in. I believe Johnson allowed that, despite the fact that Johnson's being a case relied upon by the defense here. That case, despite the fact that they found testimony was no good, they were allowing them to have another hearing to actually admit that testimony. I believe that also goes into the Bellet case, which was a main focus here.
My more concern, sorry if I was unclear, was that on remand that you would have to satisfy some exception to the hearsay rule or that it's not actually hearsay. There would need to be something like that rather than just a full restitution hearing where hearsay is allowed.
Well, Your Honor, I would still argue that based on the statutory text here, hearsay is certainly allowed. We would just possibly need to make it clear on the record that we have a minimal indicia of reliability. I would, even though this is not featured in Chapter 90 of our evidence code, I mean, this is a hearsay exception essentially built into the restitution statute. This is only applying here. And here, the text of our statute under 089 is telling us that hearsay may be admitted with a minimal indicia of reliability. It's not like VOP where we can rely on hearsay, but it can't be the only thing. Nothing in this statute says it must be something more than hearsay, just hearsay with a minimal indicia of reliability. And again, with the victim's testimony that we received here, I think that we had more than enough of a minimal indicia of reliability. I think he gave us a maximum indicia of reliability based on his familiarity with his work, what he was capable of doing before he was attacked. And unfortunately, the fact that he was no longer able to continue this business and had to close it down after this happened. So but of course, Your Honor, if this court held that it must be hearsay with an exception, or that hearsay with the exception is the minimum indicia of reliability, of course, the state would be able to admit that evidence at a remanded hearing in the event this court found that that was the way that this case must be remanded. But if this court has no other questions regarding these issues, I will rely on my brief and I ask that you affirm.
Thank you, counsel. You may proceed.
Yes, you are. Turning first to the indicia of reliability, I would point out, as Judge Brownlee has mentioned, there were a lot of statements made that were relatively vague by the alleged victim in this matter. I make between $2,000 and $3,000 a month, between $75,000 to $100,000 a year. If he did in fact have that personal knowledge, he'd be able to do more than just to estimate how much he makes. I would argue that the rule exists under the case law because of that indicia of reliability is very important. If there is something that indicates that, you know, what the person who is proffering his testimony is in fact saying isn't 100% accurate, or there might be some question as to it, I would argue that that raises questions as to the indicia of that testimony's reliability.
But counsel, you agree the whole indicia of reliability only applies if it's hearsay evidence.
Correct. I would agree with that, Your Honor. Turning to the next point regarding the testimony from the victim or regarding his inability to work or lose contracts. This occurred in 2021. That was a year directly after COVID. A lot of businesses were having difficulty in shutting down. There is no testimony proffered by the state that says the contrary. Again, in order to show restitution, there needs to be both but-for causation and proximate cause causation. And I would liken this to DJR versus state cited in my brief, which in that case, a minor had attempted to break into a store and disable the security system. Granted, the security system was in fact re-enabled prior to a subsequent burglary that occurred on the same day or in about the same time frame. But the defendant could not be found liable for the damages resulting from the second burglary. I would say that there is a superseding intervening cause here. The government also pointed out in its argument that there were questions or statements made by the alleged victim regarding his shoulder injury during the plea colloquy. The timeline of events is very important in this case, specifically the order of the batteries and what happened when the hearings. We have the first battery, which is the incident at bar that occurred in 2021. Subsequent to that, we had the battery between the victim's son and the victim himself. The plea colloquy came after that second battery prior to the restitution. I would argue that all that needs to be considered in regard to proving causation, but for causation and proximate cause causation, which I would argue is lacking in this case. All we have are statements after this battery, I couldn't work, or even in the questioning by ASA Scarborough in this matter, she asks what happened after 2021. She says, did your health decline after the battery that occurred in 2021? Again, Mr. O'Berry is 75 years old at this point. And even then, there was no scientific evidence that was proffered by the state to show that these injuries weren't caused by something else, such as age or repetitive motions like with fixing fences. The state had the opportunity to have that evidence with our expert, had he been permitted to testify, to show that there was some indicia of reliability to what he was saying. It could have went either way. That would have gotten to the truth of the matter, which is what we're here to determine today. And for the foregoing reasons, Your Honor, I would ask that this honorable court reverse the ruling of the lower court. Thank you.
Thank you, counsel. This court will be in recess.